Great to see some friendly face names in the chat. Thank you for being here. Just give it another minute and then we will start. If everyone wants to, panelists want to just do a quick stretch with me before we begin for the next hour, that would be lovely. Okay. All right, let's get moving. So welcome everyone. Thank you so much for joining us today for the launch of our global report, Exclusion in Practice, a human rights analysis on the legal barriers to advancing community justice. A few logistical items before we get moving. We have live interpretation today in 4 languages. We have Cynthia and Daniela, who will be interpreting in Portuguese. We have Flavia and Julia, who will be interpreting in French. We have Maggie and Martha, who will be interpreting in Spanish. And we have Yogi, who will be interpreting in Bahasa. So please do take the time you should have the live interpretation button on the bottom bar to select the room that makes sense for you. And if you have any questions or issues related to that, please do put that into the chat. And we really do hope that this is interactive to the extent it can be. So please do also share reflections, share questions. It's a powerhouse of folks who have come together, not only the panelists, but all of you. And so we really want to honor the expertise and experiences that you all bring to this conversation. So let's get started. My name, everybody, is Sukti Dital. I am the Executive Director of the Bernstein Institute for Human Rights at NYU School of Law. The Bernstein Institute is a center committed to challenging legal systems that exclude, marginalize, and oppress. And we do this primarily by advancing research, education, and advocacy on legal empowerment in the United States and globally. What do we define as legal empowerment? We see legal empowerment as a methodology that centers directly impacted communities in their justice struggles and is rooted in democratizing and disrupting the way law is understood, law is used, and eventually shaped and transformed. And at the Institute, that vision is really our North Star. We envision a world where the law is rooted in human rights, where legal systems are equitable and accessible to all people, and lawyers take a step back. But they're vital. They work in partnership with communities to help build power and advance justice. Today's report is central to that vision. Exclusion in Practice has truly been a project in motion, years in the making. As the legal empowerment community grows and more of us see the value, urgency, and importance of community justice as a solution to the world's most pressing injustice issues, we are also seeing with increasing clarity the barriers that limit an open, vibrant, and inclusive legal system. As context, there are 5.1 billion people worldwide who lack meaningful access to justice. Democratic backsliding, climate emergencies, income inequalities exacerbate this justice crisis. And for those living on the margins, a medical emergency, an eviction, an arrest, a change in your immigration status hurls you deeper into poverty, puts yourself and your family at risk for a host of things, including incarceration, family separation, or death. And even with this, even knowing this, most of us are denied access to meaningful legal support. And we're left to navigate very, very technical, a labyrinth of laws and regulations and court systems alone. This is where community justice workers or community paralegals, barefoot lawyers, community advocates, we have many names, this is where they step in, and this is where we'll hear directly from folks like Anthony, who is a community justice worker. Worldwide, as many of you may know, community justice workers really bridge gaps between community members and justice systems. They partner beautifully with lawyers. They play a vital role in the legal ecosystem. They help raise awareness around rights violations. They accompany, they empower, they counsel, they teach. And they really breach a deep and costly justice gap as well. Most of them do not have traditional training in the ways we think about for lawyers, but they have quite rigorous training, both from organizations that they are partnering with and from their lived experience of understanding how to navigate systems. And yet there are barriers that they experience to be able to really do their work in the ways that they imagine and the ways that are necessary for us to address the world's injustices. This report brings visibility to one of those barriers. It is the ability of community justice workers to fully participate in the legal ecosystem. And it's told through a mix of research and analysis and 8 global case studies that try to bring visibility and unpack harmful laws that regulate legal practice. To be clear, we are focused on harmful laws, those that are overly burdensome, those that are vague, those that are unnecessarily restrictive, that can penalize, criminalize, and limit the ability for these incredible justice advocates to do their work and serve the communities that they work alongside. So today, we are blessed to have 4 fantastic humans and legal empowerment practitioners and experts to join us in a conversation around this very issue. They have contributed significantly to the making of this report, in particular, Alejandra Torres, who is the primary author, and are living proof of the power and promise of what legal empowerment can do to address injustice. So we have Anthony Jenga from Kenya. Anthony, if you could raise your hand and say hi to our community. Anthony is a voluntary community paralegal and civic educator. Nice to see you. We have Meg Satterthwaite, who is the UN Special Rapporteur on the independence of lawyers and judges. She's also the faculty director of the Bernstein Institute. We are quite lucky. We have Alejandra Torres, who was the Legal Empowerment Fellow at the Bernstein Institute for Human Rights, and as I mentioned, was the primary author of this report. And we have Fabio Yonesta, who, namaste, who is the head of the Pro Bono Department of the Indonesian Bar Association, who is zooming in from Indonesia. So, what are we going to do today? I'm going to ask questions to our wonderful panelists. We're then going to have a collective conversation around the report, some of the challenges that were identified, and also to really bring visibility to the recommendations. There are actually concrete ways in which we can solve this problem. So we really want to spend some time on those as well. And then we want to open it up. If there are burning questions in the room, please, as we continue the conversation, please do add them to the chat. We will be taking notes of that, and then we will turn it over to make sure that this really becomes a collective conversation, not only in identifying problems, but in terms of identifying solutions. And so with that, we will turn it over to Alejandra. So Alejandra, and feel free to bring a little bit of yourself and your history of your work into however makes sense. But if you could share with us today the motivation behind the drafting of this report, like what were the goals and the aims of the report and how do they relate to human rights?
Hello, everyone. Thank you so much, Fifty, for that introduction, for grounding us, and for the question. So briefly, I will mention that I went to law school at NYU. I graduated 2 years ago. And frankly, I was a little frustrated with the legal education system, the legal profession. It felt a little exclusionary, or rather, we weren't really learning about how to work in partnership with communities and with community justice workers. So as I learned more about legal empowerment, which we will discuss further today, and Meg will certainly speak about, and about community justice workers, I totally changed my perspective and realized that there's so much we can do when we work in partnership. So now I'll talk a little bit about the report itself. This report builds on a submission to the Inter-American Commission on Human Rights that the Bernstein Institute wrote before I was at the Institute. So in it, the team called for a thematic hearing, and argued that overly broad, unauthorized practice of law regulations in the United States exacerbate the justice gap, and impact former jailhouse lawyers. So these are folks who are incarcerated and they teach themselves the law to advocate for themselves and their peers while in jail, and they're a type of community justice worker. But when jailhouse lawyers return home and they want to continue serving their community and using those skills, they risk being accused of violating the law and even being criminalized. So the goal of this report is to adopt a more global approach, because if the challenges exist in the US, if this particular challenge exists here, does it exist in other countries? And the answer is a resounding yes, as seen by our panelists who are coming in from other countries. So as Supti mentioned, around the world, 5.1 billion people lack meaningful access to justice. That's incredible. That means that so many people don't have legal support to resolve their justice and law-related issues, like something like fighting an eviction notice or a deportation order, or maybe very simply a dispute with their neighbor. And community justice workers fill this critical justice gap. As we mentioned, they're not law school graduates or trained or members of the bar, but they're trained in areas of the law and crucial skills like organizing, advocacy. They are usually members of the communities they serve, and they help these communities resolve law-related issues and are important legal actors in the legal ecosystem, especially when lawyers are scarce or expensive, or they're simply not equipped to help people with everyday or life-affecting problems. So in this way, community justice workers are not replacing lawyers, but they're performing complementary roles to them. They're stepping in when lawyers are inaccessible. Now, if we're talking about ensuring that people can have a roof over their heads or remain in their chosen country with their families, then community justice workers are protecting human rights and are thus human rights defenders. And this is something we argue in the report. But when experienced community justice workers are not permitted or are criminalized for filling in this justice gap, well, that presents a major human rights issue. And as the report goes into detail, a huge barrier to their justice work are laws that regulate legal practice that are vague, restrictive, overly burdensome, or non-existent. And this is a term of art we created for the report. So laws that regulate legal practice vary in shape and size. They are those that regulate the conduct, discipline, functions, and qualifications of those who are allowed to exercise the legal profession. They look differently in different countries. And returning to the background of this report, in the US, for example, these laws are unauthorized practice of law regulation. So the report highlights the diversity and complexity of laws that regulate legal practice by showcasing 8 countries: the United States, Ontario, Canada, Colombia, Indonesia, where Febi is from, the Philippines, Kenya, where Anthony is from, Sierra Leone, and Uganda. And these countries' laws, policies, regulations are in conversation with each other in this report. When these laws that regulate legal practice are prohibitive and disregard community justice workers or create burdensome and unrealistic requirements for them to continue doing their work, then community justice workers are not able to close the justice gap in their communities. So consider the following scenario. You have an underserved person who can't go to criminal court with their choice of legal counsel, maybe because it's expensive or it's removed from their indigenous or traditional community. The judge doesn't understand their situation. Maybe free lawyers are scarce or under-resourced, they don't look like them. That person cannot turn to an experienced community justice worker to pursue alternate justice routes or acquire the necessary legal resources to carry out their cases self-represented, because a community justice worker might be threatened with violating such laws. or the community justice worker still hasn't been certified for the law-related work they have done for years as a human rights defender because the accreditation process is slow and underfunded, or accreditation requirements encroach on the community justice workers' autonomy and ability to remain grassroots oriented. So how can that underserved person realize their human rights to access to justice, equality, information, and a fair trial? Laws that regulate legal practice that restrict experienced community justice workers from participating in legal ecosystems in partnership with lawyers to advance the human rights of their communities, thus violate key human rights principles. The report offers a novel approach to advocating for reforming, repealing, and ratifying these laws. Recognizing and supporting community justice workers like Anthony is a matter of human rights. And the report includes a variety of recommendations on reform, recognition, protection, regulation, composition, capacity and funding, legal education and services. So we really encourage you all to dive deep into the report once we publish it, once it goes live after this. And the report really is intended to be an advocacy tool for activists, lawyers, community justice workers to encourage change in the legal landscape, and for lawyers and community justice workers to partner to ensure that together they increase access to justice for those most in need. Thank you.
Thank you, Alejandra. That was a really beautiful, I think, overview of the report, the aims, the invisibility, and also concrete ways in which we're thinking about how can we address this harm. The report is live. Gabby has put it on in the chat, so if you'd like to access it, you can download it from our website. And I think we will now turn it over to Anthony. So Anthony, if you can tell us from your lived experience a little bit about your work as a community justice worker in Kenya. Maybe walk us through how you help bridge the justice gap between the communities that you partner with and the legal system. Thank you.
Thank you very much, Shukti. Actually, Alejandra seems to have just said everything that happens on the ground, so I can only say it in my own words. But basically, perhaps what I can start by saying is that the critical issue in Kenya is ignorance and fear among the citizens. And that's because for many years, and it's perhaps due to the colonial past, the law has always been perceived as a tool for the government to suppress, control, not as a facilitator for order and justice. So to many ordinary Kenyans, every time they think of the law, they go on their guard. So for many Kenyans, though, again, the courts are not seen as areas where you get justice. Actually, they see it as a gateway to the prison. So not as a places where they will get justice. And for this reason, this is actually one of the major reasons why the community paralegals come in and are so important. And it's my role, we try to demystify the law, and we help the citizens understand how the justice system works, guiding them through when they find themselves in those entangled legal issues. So as a community paralegal in Nairobi, Kenya, and I live in the peri-urban setting where it's both city and rural, it's a rural setting where city laws apply. So it's even more difficult because the city laws tend to be a bit tight, very tight, but they apply to this community, which is really peri-urban. We have poor people, you have farmers, you have people who basically don't even have, some of them don't even have state identification documents. So I spend a significant amount of time explaining how the law relates to their individual situations, even convincing them that getting registered by the government or to the national health system is good for them. Even that still is a role that one of the roles I play. And of course, whenever they're in conflict with the law, we try to show them how they can use the law to actually protect themselves rather than fear it as something that will take them into prison. And also perhaps how to, especially the informal business community where you have village women, you know, and I'm talking about, you know, this is very common in Kenya, where women run small kiosks on the roadside, you know, selling vegetables and things. So they are still supposed to pay licensing fees and that sort of, you know, and another, and abide to health regulations.
Anthony, I think we might be losing you a little bit.
So in the
Mm. Maybe, yeah. Anthony, would you like maybe turn off your video because the network is a bit challenging? Gabby, could you message him? I think we might need to pause and then come back. Okay, so maybe we'll come back to Anthony.
To comply to these regulations. I help them to interpret particular circumstances, you can say. You can get me clear, I hope.
Now
So
we can, yes.
perhaps I can add that many cities can.
We love and hate you technology. Okay, so we will come back to Anthony. I felt like there was so much he was sharing that was so essential. So we will come back to Anthony. We will turn to you, Fabio. Fabio, if you can share with us, as a lawyer and a true champion of legal empowerment, you have experienced firsthand the power of what community justice work can do in Indonesia. Can you share from your perspective as a legal empowerment practitioner, as a lawyer, the importance of collaboration between attorneys and community justice workers? Like, what's the importance of it? Why do you do it? Why do you think others should do it? What are the positive impacts that can emerge from a really strong collaboration?
Okay. Good evening, everyone. Good evening from Indonesia. So, Sukti, responding to your questions. So, I have been working as a public interest and human rights lawyers at the Legal Aid Foundation, based in Jakarta for about 15 years. And besides doing human rights litigation, I also do community legal empowerment, where I collaborate with community paralegal. You use community justice workers the same meaning, had the same meaning in building their legal capacity and doing human rights advocacy. So after leaving the Legal Aid Foundation, I continue to develop pro bono initiative with the Indonesian Bar Association to build lawyers' awareness and making real contribution to the society, specifically the underprivileged. So from my experience, I learned that due to the like number of lawyers who are willing and capable in defending the community rights, the community are prone to from experiencing injustices, including unfair trial, miscarriage of justice, malicious prosecution, judicial harassment, or even torture. Therefore, we invest more on empowering the community to enable them overcome the lack of access to justice as well as to defend their own right. I guess the positive impact from working alongside the community justice worker, that their existence have been filling the gap between lawyers and the community they represent. Community justice workers are the people who really close to the community or even part of the community itself. They know better the community legal need and what would be the best solution for them. While lawyers sometimes a bit distant from the community and fail to understand what the community really needs. So the most important aspect about collaborating with community justice worker is not just formally involving the community in the decision-making process, but rather substantially leaving the decision-making in their own hands. And this would only possible when we collaborate with the community justice worker. And interestingly, community justice worker may have ideas or approach that lawyers would never think of. They are able to interpret and adapt the legal language and legal frameworks to the community socials and cultural conditions and make a more effective legal strategy to pursue structural change. That's my response. And back to you, Sukti.
So powerful, Fabio. I think there's a lot there that we will come back to, especially when thinking about things that you can't imagine, you know, like the law, what you might get from a legal education is important, and yet there are, you know, your imagination can sometimes be limited, not only from the education you receive, but maybe from your lived experience. And so thank you for really naming the radical possibilities if we actually partner in this way. Before I turn to you, Meg, I just want to see if Anthony, we are okay network-wise, because I want to just make sure you have enough time to finish. We were all really, really listening with every word. You were talking about the conflict of law with the informal business community, and then we lost you. So I just want to make sure you have time to be able to finish your thoughts, Anthony.
Yeah, it happens only when I come on. It's not happening to anybody else. I wonder why. But basically, one other thing is that most of the citizens in our country, they believe the police are the custodians of the law only. And so they are completely unaware of the separation and independence between the police, the prosecutor's office, and the judiciary. So we have to carry out a lot of civic education to get them to know that when they go to a police station, when we walk them to a police station, they are not convicted, because basically that is the thing, that anytime somebody has to go to a police station, that's it. Or they see a policeman walking, they are demoralized. They see their life has come to an end. So we try very hard to make them realize that it's just a process in the law. Okay, and work with them to the police stations, and to accompany them and to just make sure they don't get intimidated, because a lot of people get into trouble because they fall for the intimidation. And unfortunately, it's unfortunate because our country fell into a very deep hole of corruption. And so most of the law enforcers put people in a situation of extortion. So the one thing they would do is to make you fear so that you can pay not to go into the police station. So a lot of times what we have to do is to ensure that the people do not fall to that extortion. And it is a lot. It happens a lot of times. Okay. And whenever, like when I have a case and I'm dealing with it and I find, yes, this case either as a rights case, so where a person is actually seeking justice against, say, another organization or another person, or when they themselves are the victims of a conflict with the law, then since we are not allowed to go into court, then at least where I work, it's easier for me because we can refer the case to our supervisor, that is the Kituo cha Sheria in Nairobi. Kituo cha Sheria is a legal empowerment center, and it is able to provide pro bono. I think for now that I would say that. Thank you.
Thank you so much, Anthony. We really appreciate your perspective around the law as it has been a tool of fear and terrorization for many communities, and that, I mean, just indispensable role that community justice workers like yourselves play in accompaniment, in bringing, being that source of comfort and being a source of understanding to be able to engage and try to seek benefits that are their rights. And so we recognize, and I think Meg, your paper you wrote around critical legal empowerment really, really centers that idea of the law historically has been a tool that has been oppressive to many communities. And how can we think about the law as emancipatory in certain ways? And I think the role of community justice workers in recognizing that history, but then also recognizing what might be possible is really essential. So thank you, Anthony. Okay, so Meg, over to you. In your first report to the General Assembly, you underlined the promise of legal empowerment in advancing access to justice for all. Can you share in your work in putting that report together, if the issue of exclusion, as we're thinking about it today, emerged, and if yes, in what way?
Thanks so much, Sukti. And I'm just really happy to be with you all today. It is always inspiring to hear stories of people doing the work and making justice happen in real lives. So thank you so much. It's an honor to be here. I also want to shout out again, Alejandra Torres, because she was a big part of helping to prepare this report for the General Assembly. So I want to note the obvious here, which is that our panel has both community justice workers and lawyers on it, and that really when we unite and when we partner, which I think has been described so effectively, that's when we really are able to ensure that these communities that have been either harmed by the law or pushed out of the protection of the law can, in their daily lives, start to use the law to access their rights and protect themselves. So to really respond to your question, though, in the consultations that we conducted for this report, we found that yes, indeed, one of the common challenges for community justice workers is the prohibition or even punishment for the work that they do through laws and regulations that, as you have described, can be overly broad, vague, and they can therefore inadvertently often target community justice workers. Community justice workers, of course, are not lawyers, and lawyers have distinct requirements and roles, and of course, also distinct accountability structures that apply to them. And it's important to acknowledge that affirmative legal recognition and regulation of community justice workers is complex. It's not an easy thing. And it should be approached, I think, contextually and very much with the voice of community justice workers themselves in the lead, so that it can be aimed at recognizing the important work community justice workers are doing, while ensuring that community members seeking help with justice problems can be confident that those community justice workers are competent, ethical, and accountable, just like we would ask of any justice worker. In different contexts, these goals have been pursued in different ways. So licensing or certification schemes, or through, of course, rules that require supervision by lawyers. And we might talk in the Q&A about how that can be very limiting in some circumstances. But one of the key bottom lines, I think, is the need to decriminalize work by community justice workers. There is really no way to describe the fear of living under this kind of the criminal law as a potential axe that could come down when you're simply trying to help communities access their rights. So there are alternatives that have worked, and I think I see actually Michelle Leering from Canada. So she has been involved in one of those really pioneering and important efforts to create optional licensing schemes for paralegals, or create systems of supervision for community justice workers who are working within community legal clinics. And in other places, there are licenses or certification granted for practice before different kinds of government agencies or tribunals. So sometimes it's sectorally specific. So there are different methods of regulating these things. And it's the same for legal practice. Legal practice is differently regulated around the world as well. And no matter the regulatory arrangements, for lawyers, Principle 25 of the Basic Principles on the Role of Lawyers provide that professional associations shall cooperate with governments to ensure that everyone has effective and equal access to legal services. So it's right at the heart of lawyers' obligation is to ensure access to justice equally for all. And so that really gives, I think, a real grounding for seeking the partnership of bar associations and other kinds of lawyers' organizations. But I do think, given the magnitude of the justice gap, as you've described it, Sukti, and then as we've heard about it in these different contexts, the uneven supply of lawyers in many places there is this justice gap that will go unmet if we're only looking to lawyers. And I've been really inspired by seeing that lawyers organizations are actively embracing and supporting legal empowerment models, partnering with community justice workers. And both Feby and Anthony have given these wonderful examples, I think, of the expertise that community justice workers bring to the table. And they bring new ideas, expertise in problems, but also ideas about new solutions that we as lawyers may not think of. And that really shows that as we are right now in the last 5 years of the Sustainable Development Goals, and the world promised to achieve access to justice for all in goal 16, we've got to not do things the same way we always have. And we need to be embracing these solutions that are capable of reaching everyone. And so my message really is we've got to get rid of the barriers to that, embrace the innovation that community justice workers bring, and really step out and partner for these amazing and effective solutions to justice problems. Back to you, Sukhi.
Thank you, Meg. That was wonderful. And there's a lot there that I think we'll come back to with regards to thinking about the recommendations that were articulated in the report. So now I'm going to transition into, and I apologize for the noise in the background, a couple questions towards Feby, Anthony, and Alejandra. And in particular, so the report goes into, it details harms that underserved communities and community justice workers are experiencing as a result of these types of laws, specifically those that are quite vague, those that are overly burdensome, as they relate to regulations around legal practice. It would be really, I think, illuminating for the people in the room to hear what that harm might look like for the people, either as a community member yourself, as a community paralegal, or as one who is active in justice struggles. Meg, you touched upon this a bit with regards to criminalization, but I think Alejandra, having your identity both here as someone who lives in the US and authoring this report, we'd love to hear examples of how these harms, what these harms are and how do they impact justice work.
I'm starting.
Are you okay with that? We can.
Yeah, of course. Sorry, because I heard Meg and Alejandra. I apologize. All right, I am ready. Okay. So just again, some context. I was born in Colombia. Colombia is one of the countries that are highlighted in the report, but I went to law school in the US. I work here, so I can speak a little bit about the difficulties from the US perspective. So we got a lot of, very gratefully, US-based legal empowerment practitioners who provided feedback on the report, and many of whom are lawyers, and they underscored the importance of community justice workers working alongside them, but they have to tread lightly. And I just saw Bakura Shabaz's message in the chat. Like, she is a living, breathing example of a lot of folks who are non-lawyer advocates who are trying to support their communities, but they're often in harm's way of being accused of violating the law. And they're not intentionally trying to violate the law. They're simply supporting their community. So I'll provide more information. So in the United States, the vague and restrictive laws that regulate legal practice are usually come in the form of the unauthorized practice of law. And these regulations vary from state to state. And I'll use UPL for short. And they're very harmful to a lot of folks, but in particular, we highlight jailhouse lawyers. And there's a story of Jody Polk, the founder of the Jailhouse Lawyers Initiative, in the report. So again, jailhouse lawyers, they're permitted to do legal work while incarcerated. And once they're released, that right disappears, which feels a little counterproductive. If they give legal information to their friend or their neighbor, they might raise the UPL alarm. Why is that the case? because these UPL laws are often drafted so vaguely, yet they still carry criminal penalties, but there's no clear definition or explanation about what legal information is, what legal advice is, and certainly no inclusion of the, to use Meg's terminology, of the innovation of community justice workers. So these laws create a distinct dichotomy by those who can provide legal advice, whatever that means, and those who are unethical and pretend to be a lawyer and thus must be criminalized. So there's no in between for community justice workers, or they're helping their communities, responding to court notices, informing on what court documents they might need, but they don't, like, the law doesn't really envision that type of work. And who better to support someone going through the criminal legal system than someone who was formerly incarcerated and has lived the law? A criminal defense lawyer would benefit from hiring a former jailhouse lawyer at their firm because they understand the impacts of the law and the reality on the ground. Yet many states in the US criminalize these possibilities of increased options for support and collaboration. Another key example is in the immigration context. Again, these UPL regulations pose a major challenge to community justice workers. We highlight in the report that the US is very unique and that there's so much going on. And one thing is the federal government does create caveats for some non-lawyer advocates, and they're known as accredited representatives, and they can represent immigrants in immigration court. But as of December 2023, there were less than 2,300 accredited representatives. That's a woefully small number for the amount of people who need help. And there are definitely not enough lawyers for every immigrant who needs legal support. These examples show that vague and restrictive UPL laws in the United States harm communities that need help with these life-affecting problems, but they can't rely on community justice workers because community justice workers might be criminalized for their justice work. So as Meg emphasized, the decriminalization of their work is so important. And to tie it back to the human rights analysis, well, this violates their human rights when they're presented with limited options in how to resolve their justice problems if they can neither rely on lawyers nor community justice workers. But there is hope. We in the report and in this panel, we're hoping that the conversation moving forward shows that we can envision a world in which vague, restrictive, overly burdensome laws that regulate legal practice are repealed and reformed to increase access to justice for communities, and let community justice workers such as Bakura do their justice work and work in partnership with lawyers.
Thank you so much, Alejandra. One of the things we just wanted to name also in terms of the motivation behind this report is that there is an increasing momentum, as I mentioned, around legal empowerment being seen as a viable solution. And we want to honor the fact that there is organizing starting to happen around reform of these regulations in the United States and in other countries. And so we're not the first ones out in the door kind of putting this into conversation. I think what we hoped to do as part of this report is to embed it in a human rights analysis. Oftentimes this is seen as quite niche. It's seen quite administrative. It has almost like a sterile, it doesn't really impact the human. And so what we're trying to do through this report is to really have it be a narrative change, but also an organizing tool around the impact of this as a human rights violation. So just wanted to name that also as we continue the conversation. Anthony, hopefully your network is still with us. US is quite different from Kenya on 1,000 different levels, particularly when we're thinking about these laws that regulate legal practice. As you'll see in the report and from your lived experience, Kenya is kind of on the other end of having actually tried to have a law that recognizes the work of paralegals. Can you talk a bit about the harm that you're experiencing being in a context where there are actually laws in the books that are meant to recognize the work that you do? What are some of the things you're dealing with that limit your ability to do community justice work?
Thank you, Sakti. Perhaps maybe I should give you the background of the Legal Aid Act of Kenya 2016. Actually, it did not come about because to recognize paralegals as such. It's a result of activating a part of our constitution on access to justice. That's Article 48 of the Constitution of Kenya, part of the rights. So paralegal is just mentioned as a by the way, and actually in the Legal Aid Act, it's actually talking about legal assistance in lawyers' offices or in the courts. It does not quite mention at all a community paralegal. But we are happy that at least the word paralegal does exist, and we are trying very much now work to it so to be amended so that it does mention community paralegal. So much as it has been mentioned, it does not give us, what it does is it lays out the do nots rather than the do's. Okay, and one of the major do nots is do not trample on the toes of lawyers and advocates. It's very protective of the role of the advocates. And I think at the same time, it's really not the first law that talks about legal aid, because there is also the Advocates Act, which says very clearly there are certain areas that only an advocate will act. And especially in matters to do with land where there is money changing hands, the advocates, the lawyers are very protective of this. And then comes the matter of putting your pen on any document that is going to a court of law. Again, extremely protective. You cannot even sign on behalf. Though a legal assistant in a lawyer's office might be able to do it, but the moment a community paralegal steps there, it becomes a big hunt by the lawyers, and that's when they all gang up. Yes, because you are called a masquerader, you are a pirate, you are everything bad that can happen to the legal community. So in many ways, it doesn't give us any leeway, but regulations have come up now to give some beef onto the Legal Aid Act. And this is where perhaps you now begin to see the emergence of a paralegal, remotely, not exactly using the word community paralegal, but remotely suggesting. But then again, you cannot, you are supposed to be registered with a society. It says that, but you cannot be accredited on your own as a paralegal. You can only be accredited if you're working under a lawyer or you're working under an organization. But you as a paralegal, Anthony Njenga, cannot be accredited. Perhaps the Paralegal Society of Kenya will be, but not you as a person. Whereas on the other side, on the flip side of the coin, an advocate is accredited on their own. They don't have to be accredited. They don't have, it's the Law Society of Kenya is not the reason they have called. But for us, you have to be accredited to Paralegal Society of Kenya. And if you are not, regardless of your qualifications, sorry, you're not a paralegal. You cannot, only a paralegal by word. So there is the history of how most of the paralegals came about. They came about because of the need by the communities. So it was not a matter where you went to school to learn law to be able to serve. You were there as an activist because of one thing or the other, and then suddenly you found yourself protecting people. So gradually you learned law, and some people, not myself, have been in it for 20, 25 years almost. But according to what the regulations say, you are actually supposed to go through, say, 2 or 3 years of study to be accredited. Although there is a little window for what they call experiential learning. But so far, it's not been actually, none of the paralegals in Kenya has used that as a path to be recognized or to be accredited. So we are still there in limbo. We feel unsafe. And I have a recent case where a very experienced community paralegal did sign a document that was basically a document to support alternative justice, meaning, you know, an agreement. And since it was a case that was in court, the moment that paper got there, oh, the amount of wrath that this paralegal has had to go through is amazing. And the threats, okay? So anything, basically, we cannot touch money because the regulations do not allow us to charge for the services we offer. It says very clearly that you must not collect any fees. On the other side, the government does say in the act that the National Legal Aid Service can pay you. But then again, here, you cannot go to court. Here, it's you cannot go to court. So the question arises, what will you be paid for? Because the measure, the criteria for you to be, is actually taking a case to the court. So as a community paralegal, you'll not get there. So it's actually just there, it's just paper. We are working on a code of conduct, a national code of conduct for community paralegals. It's still not in the works. It's being worked on by the law school here in Kenya, but then it cannot go against what the regulations and the Legal Aid Act says. So it's actually, we are stuck there. Thank you for now.
Anthony, we feel the dizzying nature of all of this. I think this is a snapshot of how complex this issue is, which is, I think, something that Alejandra and Meg underlined. This is context specific, and we want to reiterate that. Human rights, I mean, there is a floor and there's a basis for that, which is what we're really anchoring the analysis on. But Anthony, it's complicated. It's around financial, economic mobility. It's around safety. It's around being recognized for your particular type of work as a community paralegal versus just a general, more professionalized paralegal. So we recognize and we empathize with you in terms of the challenges that you're experiencing. In part because sometimes countries like Kenya are seen as the vision of where we should be moving. And I think it's also a cautionary tale around what does it mean to move forward and have inclusion of paralegals in some form. Another complicated country context, but very rich in its history, and Fabio has been really central to a lot of the work there, is Indonesia. So Fabi, if you can help us understand, maybe highlight some of the harms and some of the promise that has emerged from Indonesia, I think that would be really, really useful.
Okay, thank you, Sukti. So in my interaction with community paralegal, I learned that the most crucial challenge are about recognition and protection. Even though paralegal has been regulated in Indonesia legal aid law, but in reality of legal practices, they are still being undermined by law enforcement and even facing risks of being attacked, harassed, criminalized, or facing slaps. And in the advocate law of 2003, it used to have a specific provision that may criminalize non-lawyer who provide legal assistance. Fortunately, it was revoked by the Constitutional Court responding to the petition filed by a university legal clinic. There was also an attempt to exclude the role of paralegal in legal aid provisions. In 2018, there were a group of lawyers who filed a petition to the Supreme Court to exclude paralegal from providing legal aid, both in litigation and non-litigation. Some and later on, some civil societies, organizations, networks then conduct a public examination against the Supreme Court decisions, which then recommend a revision to the paralegal ministerial regulation that at least paralegal is now allowed to do their justice work, but not independently. Although the existence of paralegal has been formally recognized through the ministerial regulation, such formal recognition may exclude community paralegals who find it very difficult to meet the requirements set by the regulations, such as literacy requirement, competency standards, and registration procedures. For community paralegal who come from remote communities and may be illiterate, such requirement will hinder their participation in justice work. Back to you, Gary. Sukti, sorry.
Yes, yeah. No, thank you. And I think, yeah, again, touches on what were, again, context specific, but overly burdensome requirements that then in a way negate the ability for people to engage in this justice work that's so essential. So thank you, Vebi. And you will see in the report that there are quite detailed case studies on each of the country contexts that are represented here, but then also 5 others. And so we do urge you all to take a look. And again, want to underline that this is a continuing conversation that we hope to have. We recognize that this is not the end at all. So speaking of the report, it outlines a number of recommendations. And Alejandra, you spoke a bit about the different categories around recognition, reform, funding. Can you talk about, and maybe I can say that this is for clarity purposes, the report recommendations are targeted at 2 specific types of regulatory bodies. One are state regulatory bodies, which under human rights law have a higher obligation versus non-state. So who do we mean when we talk about state regulatory bodies? We're talking about the legislature, we're talking about courts, we're talking about government-run legal aid or public defender systems. And then the second category are the non-state bodies. And these are folks like the bar associations and other legal independent bodies. Both of these bodies are incredibly important and powerful in the conversations that we're having, but under the way that law is constructed, they have different types of requirements and obligations. And so we were very intentional to be able to separate in the recommendations who we're talking to. And so in that, what we have outlined are a range of different types of recommendations, as I mentioned, that range from protection and funding to reform and recognition, among others. For my wonderful panelists, if you were to take a look at the recommendations again, what stands out to you as the most urgent in your home country and why? Alejandra, I'm going to have you go again, and then we'll kind of go down the line. Thanks.
I'll be brief, and I've mentioned this before. I think in the US, absolutely the most important is the repeal or the reform of the reform of UPL regulations that are ambiguous and criminalize community justice workers. We do absolutely need regulations that protect clients, consumers against unethical and unscrupulous both lawyers and non-lawyers, people posing as lawyers. But you can have both. You can protect consumers and clients and allow for community justice workers to support these folks. And so what we need is very clear laws that distinguish lawyers, community justice workers, and unethical folks, and as well include protections for these types of legal actors so that they're able to carry out their work without being without the threat of being criminalized or harassed. And so when these UPL laws, again, in the context of the US, are reformed, we can call for community justice workers and lawyers to be partners and to demand for them to change so that these laws are precise, straightforward, clearly delineate the functions of and protections for lawyers and community justice workers, and very clearly define what is impermissible conduct without confusing community justice workers with unscrupulous non-lawyers. I think we start there in the US and then we move forward. I quickly also want to say that, as you've seen, we're in the US, we're talking about UPL, maybe in Kenya and Indonesia, we're talking about legal aid acts. In other countries, we're talking about different laws. This all might seem a little confusing, but what we're trying to say is that, again, laws that regulate legal practice vary distinctly from country to country. And it's really hard to find data on this, but we're trying to put all of these types of laws in conversation with each other, because while they might differ, their impact is similar in that community justice workers might be the ones losing, and we don't want that to happen. Thank you.
Thank you so much, Alejandra. It was really helpful. And I would just add to that, that community justice workers are losing, and the communities that they're partnering with are not able to get the kind of access to justice that is indispensable to their needs. Anthony, in your home country of Kenya, you talked a bit around, the code of conduct that you all are trying to work on. What is the type of reform? If you had the main stakeholders in Kenya right in front of you on this call, what would be the reform that you think is most urgent at the moment for the work that you do? Anthony, are you there? Okay, maybe I'll give him.
Muted. No, it's okay.
Oh, okay, you're there. Okay, good.
I was muted. Sorry. I would tell them that the Legal Aid Act needs to be amended like yesterday. And the amendment would specifically recognize community-based justice workers, rather than just say the word paralegal. So I would insist they would recognize the community-based justice worker. Then I would also ask them to also amend the Advocates Act, which is an old act that sets out what the areas that are strictly for lawyers, so that the community paralegals are able to go into courts and represent the people in court, stand up for them, and not just escort them to court to give them moral support. Okay, although I do understand that that would have to be certain types of cases, definitely not murder, but then matters to do. Let me give you a short brief. In Kenya, we have a law called the Stock Theft Act. This particular law criminalizes stock theft, stealing of cattle and chicken in the same basket. And the law says you'll go to jail for 7 years. So it's regardless of whether you stole a chicken or you stole a cow. And many of the people who will go and steal a chicken have young kids of 18, barely 18. And sometimes they do it for fun because they live in the villages. And where they cannot afford a lawyer, they cannot afford an advocate. It would be quite easy for a paralegal to go in and explain to the magistrate the circumstances which drive this young kid to do what they did. At this moment, we cannot do that. And then, so I would want paralegals allowed to represent the community in certain cases that are not high stakes. Basically, that would be what I would ask today. Back to you, Sylvie.
Thank you so much, Anthony. And I will then ask the same question to you, Phoebe, someone who actually has been doing a lot of this advocacy in front of the powerful players in Indonesia. What is the reform that's most urgent where you sit?
Okay, so knowing the challenges faced by a community paralegal or community justice worker, particularly in the aspect of recognition and protection, there is a need for a change in number of areas, including the first, improving regulation by amending requirements and procedures that may exclude community justice workers, and secondly, promoting the important role of community paralegals or community justice workers in realizing access to justice to stakeholders, especially to the law enforcement officials. And the third, creating effective protection mechanism for community paralegals or community justice workers from any potential risk they may threaten their justice work. And last but not least, opening greater participation of the general public, legal professional, bar association, or private sectors to support the resources needed by communities to carry out their justice work. That's my opinion.
Thank you so much, Debbie. Really, really appreciate, especially the last call around opening up this conversation and making it more public and thinking about resources. Meg, gonna turn it over to you to kind of broaden us a bit, to talk about from your perspective, how do community justice workers advance human rights?
Thanks so much, Sukti. This has been such an incredibly rich conversation, and I'm really enjoying seeing also the comments and the ideas and the experiences in the chat, which I think are very rich. So we might bring some of those in after I finish just with a few thoughts. So first, I think it's important to remember that human rights law actually guarantees access to an independent and impartial legal system. And these legal systems have to be designed to fulfill people's justice needs. And if you see systems that are ineffective at checking abuses or solving the kinds of problems we've been talking about, and if people can't access those justice institutions equally, if communities are feeling left alienated, if they're disenfranchised, those systems are failing, and we really need to be very clear about that. And we need to pick up the work from there. And this yawning gap between what legal systems can offer and the justice problems people need help to solve is where we need to focus our attention, as we have today. There's a recent study from the Overseas Development Institute that found that less than 10% of legal needs that are problems defined in that study as problems the law could solve if appropriate legal support were available are being met in lower income countries. And in most lower income countries studied, less than 5% of such needs are being met. That's a pretty striking, I think, indictment of legal systems. That study's updating the one that you talked about, by the Task Force on Justice, which did the estimate that 5.1 billion people have lack meaningful access to justice. And I think that it updates us on the urgency of really grasping this now in the last 5 years of the SDGs. And I mentioned the SDGs because it's a way for us to remind governments and non-state actors that we've all agreed as a world community, we've agreed that justice for all is an important imperative. And so it's really about finding ways to put the funding where it needs to be, to take away the obstacles like those we've been talking about today, and make sure that we're really focusing on those frontline justice needs as we should be. And I just want to give a little bit of meat to the issue of lawyers not being able to tackle all these problems on their own. I mean, I think it's really important to remember in a lot of places, lawyers are concentrated in cities, for example. And also just the ratio of lawyers to inhabitants it varies greatly across the world. So in Burkina Faso, there's one lawyer for every 125,000 people, as an example. In Vietnam, there's one per 9,000. And then even in somewhere like the United States, where you have one lawyer for every 249 people, most low-income people don't bother to seek help because they will often say, well, I can't possibly afford the help of a lawyer if I have a legal problem. And so we need to be putting the money into systems that are really going to ensure access to the frontline support that's needed. And there has been also some really exciting research recently on the cost effectiveness of people-centered justice solutions like legal empowerment. And that work, again, from ODI is finding that the kind of funds that need to go into making sure that people like Anthony have the resources they need to do the important work they're doing in communities is very cost effective. I don't think we need to spend a lot of time in the space of cost effectiveness when we're talking about justice needs because it's a human right, but it's really important that we know that it is cost effective, and we have to bring this evidence to states so that they know that also. I just also want to bring up a comparison that's often used, and I think it's very effective when trying to find ways of really partnering with lawyers. I think it helps us to think about the comparison between community justice workers and nurses or community health workers. They're acting as force multipliers and extending kind of legal first aid to communities that might be marginalized, isolated, or excluded. And as we've already said, these are folks who have their own expertise from experiencing injustice, from working hand in hand, side by side with communities, and problem solving on a daily basis. And they really do expand options for people facing legal problems and are going to enhance the work of lawyers. They'll be able to identify cases perhaps that for which lawyers are needed, that expertise is needed, and they can act as referral services for people who might otherwise be unable to find a lawyer. And really, when you talk about it, lawyers and judges know this. Lawyers know that doing the same thing the same way is not going to be sufficient to really close the justice gap we're talking about. And judges also know that they are never going to see every case that needs a legal solution. And so I want to kind of finish with a quote that I've been thinking a lot about recently. I was on a panel with a Kenyan judge who I really admire, and he said, to kind of paraphrase it, he said, most judges think of their constituents as the people who appear before them in the courtroom, but I think of things as all of my constituents being people who should appear before me or should have access to me and a solution, but who can't access me. And he was talking about, because he knows that side of the docket, as it were, is always going to be so much larger than the actual docket he sees. He sees it as his role to really partner with community justice workers and other people-centered justice solutions to make sure that people have that human right that we all have to access justice. And a final thought, right now, the impartiality and independence of justice systems around the world are under attack. There are autocratic forces in so many countries that are trying to take over justice systems. And I have seen, and I truly believe, that when community justice workers are working with communities to access justice systems, it's a way of creating an investment in the impartiality and independence of those systems. And so it's a virtuous cycle of support for making sure that those systems can't be taken over and that they are more democratically available to everyone who needs them. So just to finish on that thought, I'll hand it back to you, Sukti. And again, thank you for this wonderful conversation and for allowing me to be a small part of it.
Thank you so much, Meg. And that last point feels increasingly relevant as we think about the way democracies are backsliding across the world. We just have a few more minutes, and so just wanted to honor some of the comments and questions that were in the chat. Two questions I think are, if the panel wants to take an attempt at it. One is coming from our friend in Nepal. Namaste Mapan Nepalio, so nice to see you. It's a question around mobilization. I think this really goes to the heart of how do we build better partnerships? How do we not see this as like a zero-sum game, like it has to go with the lawyer or nobody or no lawyers and only community justice workers? Like, how do we think about collaboration? And so the question was saying that it's really hard to mobilize lawyers to get invested in this type of work. Like, how do we do that if we don't have a ton of resources? Like, we don't have the money to pay attorneys. From your experience, maybe Febi and Anthony, what has been effective as a way of mobilizing lawyers to come together and work with community paralegal justice workers? What's the incentive, if you don't have the financial incentive, I guess?
Maybe I can go a little bit there. I don't know whether I understood the question, but I would say if lawyers would see community paralegals as a kind of an upward filter for them, an upward filter meaning that they recognize that at any one time, the cases that cannot be solved at the community level, they can feel assured that the cases will be referred to them. But to be able to get that done, there would have to be goodwill, active goodwill. So a complete change in the way community paralegals are seen. Meg mentioned something very important. It's also the case in Kenya, where the judges only perhaps see 10 or 15% of the issues to do with justice. Those are the 10, 15% is what actually ever gets to court. All the other issues are sorted at the grassroots, either through the intervention of paralegals or either through informal justice systems, traditional justice systems, you see. Quite a few high, profitable cases could get to the lawyers if they would work together with, collaborate with paralegals, because we are on the ground and we are the ones who probably will be able to tell that there's a certain case involving land or succession that needs a lawyer's help, and we are able to refer. But as of this moment, as of now, we are not able to do that because the ground is hostile. Thank you, Sukhti. Back to you.
Thank you so much, Anthony. Fabi, yeah, over to you.
Okay. So in my experience working with community paralegals, that surprisingly I learned so many things from the community paralegal. They have ideas that perhaps the formal legal system can never would never have any solution for their problem, for the problems. And so I never undermine the community paralegals, even though they never attend law school, but the experience they have, and sometimes community paralegals working longer year than the lawyer themselves. So I never underestimate the community paralegals, and I learn from community paralegals in doing the justice works. That is something that lawyers would never experience if they never have any chance, any opportunity to working alongside with community paralegals. So I think if you asking about what kind of incentive that the lawyers would have, I believe that lawyers can learn so many things from from the long experience of the community paralegal in solving the justice problem.
Yeah, beautifully said, Fabi. And Alejandra, I don't know if you want to add anything to this question, maybe from your experience as a law student who felt a sense of connection to this. Like, what is it that was your incentive to be engaged and to want to partner with community justice workers in this way?
Well, I think the reality of legal education here and perhaps in other countries is that it feels very siloed, and sometimes very divorced from the reality on the ground. You are learning case law, you're learning doctrine, you're moving on. And yes, you're gaining great skills in analyzing and writing, but you're not really engaging with, like, who are the plaintiffs in this case? Like, what was this story? What was the impact of the case? You're just kind of like learning the rules and moving along. And I don't know that that's an effective way to truly engage with justice issues. And so when I learned about legal empowerment and learning about, also, it's important to decenter yourself. Yes, you went through law school, you have a JD, you're a bar member, fantastic, but it's not all about you, and you're not the only expert in the room. You might have the resources and the education to provide the case law, to provide the information, but you don't know the lived experience of others, the narratives, the ways that people are creatively looking to resolve their issues. You need to work in tandem, because everyone has different levels of expertise. And I think a lot of issues also need to be resolved in an interdisciplinary way. It's not just the law, it could be the law and science if you're talking about an environmental case, as an example. And so I think recognizing that and the limitations maybe and how we're taught to engage with the law has allowed me to look for, or rather has encouraged me to look for other ways of doing this work. And as the panelists have shared today, there's so much, there's such a wealth of knowledge that other people bring into resolving justice issues. And so I think as lawyers, as law students, we need to be open to learning further and decentering ourselves.
Thank you, Alejandra. I know we just have a few more minutes left. Just wanted to also flag the comment from Tapiwa about what naming means. So he said in Zimbabwe, the paralegals that they're working with want to be called unionists. And the reason they want to be called unionists is because unionists can actually argue in court or can represent in court. So the power of vocabulary, the power of language, even if your capacities, your expertise, your experiences might be the same, is really also really an important part of this work. And I think also touches on what Anthony was mentioning around paralegal versus community paralegal and what it means to be able to embed their work into legislation and laws. And so again, underlining the importance of having community justice workers as part of and sitting at the table with legislatures, state and non-state regulatory bodies in thinking about how do we best reform. Also want to name Bikura. It's so nice to see you here with us, Bikura, and thank you so much for being so honest and real and powerfully stating the challenges that you yourself are experiencing as a non-lawyer advocate here in Virginia. I know it can be very isolating, and we just want you to know that there is a community here with you, not only in the United States, but around the world, who sees you and experiences and has a sense of solidarity for the work that you are doing. And so thank you for sharing that in many ways it is an injustice system, not a justice system, and the harms that you experience and your resilience to keep going. We are planning to have a deeper dive into the United States, a report coming later next year. And Bakura, you will be central to the making of that report. So thank you so much for being with us and honoring your comments. Maybe we'll just take a couple minutes. There's a question from Matthew from Frontline Justice. There's context here. It's kind of a longer question, but I think Matthew's talking about a lot of the work that they're doing to really spearhead reform around unauthorized practice of law regulations here in the United States. And in particular, I think this would be useful for a couple of our panelists, is how have you used, and maybe Fabi, this is a good one from you because you have been so central to reform in Indonesia. How have you been using different strategies and engaging different stakeholders to influence reform? So Matthew talks about the fact that there's like faith-based parties, there's divergent political parties, like it's not just like one category of people that we say, okay, this is who we're going to target for reform, but it's quite diverse. And so can you share a little bit about what strategies you've used to influence reform amongst what might seem to be a diverse a range of people?
Okay. In my experience, I've been co-creating. I use this words co-creating with the government in revising the paralegal ministerial regulations, but at the same time, like maintaining that paralegal still being recognized by the regulation. So what I did actually, perhaps you are familiar with these open government partnership mechanisms, and I use that open government partnership mechanism forum to collaborate with the government in one side, but we try to also bridge the communication, the discussion with the community themselves. So it is important to make sure that that the organization that working with the government also have a a foundation, a base, the community basis, working with community basis, and that will make your work justified, and also bringing the aspiration from the community itself. And but of course, the challenge will be the from the government interest. And in at the end of the day, we need to also compromise with that interest as well. But as long as you can bring the ideas and also the interest of the community that you represent in the advocacy works, yeah, I think it will be quite effective to do that policy advocacy reform. Thank you.
Thank you so much, Febi. I realize we are coming at time. I mean, just immense gratitude first to our panelists for not only being with us today, but just the tremendous work that you all do in your individual capacities that really does have collective impact. So thank you. Special shout out again to Alejandra for tremendous amount of labor in putting together and drafting this report. Thank you to Gabby for always engineering all of the Institute's work, both substantively and with process, and to our interpreters. Thank you for being able to translate this work in the ways that it needs to be translated. And I just want to end by saying, again, we're not going anywhere. Like, this is a conversation we want to keep having. We would love for you to take the time to look at the report, to share it with your networks, and to reach out to us. We know that the stories that we have highlighted are just a minimal taste, a little small sliver of what's happening out in the world. And so please do join us in this continued conversation. And thank you so much for all you do. Take care, everybody. We will have a recording of this that we'll share out with our networks. And thank you again, Anthony, Febi, Alejandra, and Meg. Have a good evening, everybody. Bye.
Thank you.
Thank you all. Take care.
Thank you.